Good afternoon. My name is Alina Shevtsova. I am an immigration attorney from Brooklyn, New York. In today's legal speaking seminar, I would like to talk to you about what steps you have available after you lost your application to USCIS. So we're talking about what you can do after you received a denial on your application that you submitted to USCIS. Most actions will fall into three different categories depending on what you filed, what your status is, and what would be the costs of proceeding forward for you. So first of all, you can file, in most cases, you can file a motion to reopen or a motion to reconsider. Then you may file an appeal. And the third option usually would be to refile your case, to resubmit your case. How do you decide what's better to file? Well, first of all, you need to see if the law allows you, if the regulations allow you to file an appeal, or it will be something that's called motion to reopen, motion to reconsider. Technically speaking, very often almost the same thing, okay? But depending on forms, let's say one form, denial of one form, one application, you cannot technically appeal, but you can file a motion to reconsider or motion to reopen. And for another form, you can file an appeal. But sometimes you need to choose, if both options are available, then you need to choose which one you're going to go for. And the difference between these two will be this, that motion to reopen or motion to reconsider is basically going to be considered by the same office that issued the decision. An appeal is considered by a higher body, okay, a different office. So that's the difference. And sometimes, depending on the form and the cases that were before you, decisions that were before you, you can make your best bet as to what's going to work in your situation better, motion to reopen or an appeal. The cost of filing the notice of motion to reopen or reconsider or appeal is the same. It's the same form, I-290B. And again, I believe this difference between appeal and motion to reopen, it's basically came from complexity of the regulations and how the regulations were developing over time. And that's why some forms of relief, some forms of benefits that we're applying for, we cannot appeal the denials, and sometimes we can appeal. And there's always a third option, option to refile the case. But here where you need to be very careful. Why? Because very often when you file your case, you create a bridge from one application to another that covers you from certain negative consequences, for example, like an unlawful presence. And if you refile your case, that bridge will be lost. So you need to know if your particular situation falls into this standard and if refiling will be a better option for you. So what will you look at? Well, first of all, you're going to you have to know the deadlines, when you need to submit your documents, and if there is a deadline, and if the deadline will be applied to you. So let's say if you would like to refile, do you have a deadline? Will taking a little bit more time and preparing your application better have negative consequences for your case or not, right? Usually when you need to appeal, you have like 30 days, 33 days together with the mailing days. Usually, let's say for our purposes, it's 30 days. So do you have to submit something in 30 days? Because in practice, it's usually less than that. Between the time you receive the decision and the time you need to submit the decision, it will be less than 30 days. I would say like 24, 25, okay, is the most. Or you can take a little bit more time and refile the case. Let's talk about adjustment of status based on marriage. Let's say your application was denied. What would be your options? And you're not in the removal proceedings, right? So let's say it was denied because you missed the interview. You didn't know about the interview, or you didn't appear for the interview for some reason, but you do have a valid marriage and you do live with your spouse. So it's not like, you know, you didn't appear for a specific negative purpose. you can appeal the denial, but then you have to submit a fee. I believe it's $6.75 for adjustment of status, and for another form that you're going to be filing, I-130 form, right? So you will submit motion to maybe reopen and motion to reopen both petitions. So together you're going to pay double the fee, $6.75 twice, or you can refile your case and you will pay $1,760. But when you're refiling your case in this situation, you don't have a deadline. You don't need to be in a hurry most of the times, and it's probably going to be a better decision for you to refile. But again, every time it's a case specific. You need to talk to somebody like a lawyer who can give you good advice as to what's going to be working for your situation. All right. Another thing that you take into consideration is the cost. Sometimes motion to reopen, the cost of the filing for motion to reopen is higher than to refile your application. But again, then there will be other things that you need to take into consideration. If you fell out of status or not, if you still have time to refile your case or not. So that's very important. So deadlines, if your status, out of status, and the cost, those are the main three concerns you're going to have when your case is denied. And refiling. Sometimes refiling is a strategic decision. Sometimes you have to refile your case. For example, when would you do that? Very often you're going to refile I-751 petition. Why? Let's say that you filed your petition, you filed your initial petition jointly, and it was denied. And now you divorced from your spouse and you cannot refile jointly, and the joint ground that you submitted when you filed your initial petition to remove condition from your permanent residency simply does not exist anymore. You don't have a valid marriage. So you will have no choice but to refile Form I-751. By the way, there is no limit as to how many forms I-751 you can file. So that's something also to keep in mind. How will you know what to do? Well, of course, if you're not a lawyer, it will be difficult for you probably to learn everything at once. But you can start your research by going to USCIS website. And on the website, there is a list of forms, denial on which can be appealed, a denial of which can be argued via motion to reopen, motion to reconsider, and you will start your research from there. That's going to be a good research point for you to start. And of course, there are other websites and different non-for-profit organizations. They publish different manuals for people to try to act by themselves and successfully defend their case. You can read more about various forms of action you can take if your case is denied, depending on what particular relief you were filing for, on our website, www.charlottesova.com. Thank you.